on the list for today. I thought it was on for Thursday.
SJC-11767, Edgar Rodriguez v. City of Somerville.
Good morning.
Good morning.
May it please the court, my name is Jason Grossfield. I'm an assistant city solicitor for the City of Somerville. The case is before this court on the city's application for further appellate review, and the issue is whether or not the denial of a motion to dismiss plaintiff's complaint filed under the Massachusetts Tort Claims Act, Chapter 258, on the basis that the plaintiff failed to make proper presentment under 258 Section 4 before filing the lawsuit, is subject to an immediate appeal under the doctrine of present execution. The city believes the question is controlled by the court's decision in 2013 in the case of Shapiro versus City of Worcester, where the court analyzed the presentment requirement under Section 4, which provides that a civil action shall not be instituted against a public employer without first presenting the written claim in writing to the appropriate officer within 2 years of the date that the cause of action arose. And in that case, on a similar motion, this court held, and I quote, "The city is similarly authorized to seek interlocutory review of the denial of its motions to dismiss and for reconsideration as they relate to the retroactivity of the presentment requirement. As with the exceptions to the waiver of sovereign immunity, the presentment requirement is collateral to the substantive aspects of the act, and the city's right to avoid harassing litigation would be lost forever if it were unable to immediately appeal the judge's orders that the presentment requirement does not apply retroactively to the plaintiff's nuisance claims." And the city's position essentially is that what the court did in Shapiro versus Worcester is apply the standard test for the doctrine of present execution, and that similarly should apply in this case.
Now, the appeals court was noting that you can waive presentment, and said this is not an immunity, this is a defense, and therefore outside of the scope of present execution. Why is that not correct?
Well, it's interesting. First of all, I would say a couple of things. One is that the idea that present execution can only apply to immunity is not necessarily supported by the case law, and it sort of misses the boat on the two-part test that you have laid down in a number of cases. So if we look at the two-part test, does the interlocutory ruling concern an issue that's collateral to the underlying controversy? When we talk about presentment, I think as the court said in Shapiro, presentment's collateral to the underlying tort claim or nuisance claim or negligence claim as we have here. Whether or not the city was negligent in this case is not intertwined with whether or not the plaintiff first made a presentment on the city. The second part is whether or not the ruling is going to impact the party's rights in a way that can't be remedied upon a final appeal. And I think in this case, the SJC actually had a quote from a trial court decision. This was in Hill versus the MDC, which said, "One routinely characterizes the public employer as immune from suit if the Chapter 258 presentment requirements have not been met. How are those presentment requirements not part of the immunities that protect the public employer?" And I think that whether or not this court finds that presentment is an immunity from suit per se, it certainly is a requirement that is related to the immunity that a public employer has from suit. To put it another way, the condition precedent of bringing a claim under the Tort Claims Act is that you first present the claim in writing. And the purpose of that requirement is that the public employer then has an issue to know there's a claim, to investigate the claim, and to consider whether to settle the claim before filing the lawsuit.
But does anything turn on whether it's waivable?
I don't believe so. I think it's, and particularly in this case, and I haven't seen any case law that says to that effect that the present execution doctrine would turn on whether it's waivable or not.
No, but you agree that a presentment is something that can be waived.
I do.
So in other instances where we have talked about the doctrine of present execution, does it relate to matters that are or are not waivable?
Well, in some instances, the way it's come up previously is motion to dismiss an anti-SLAPP lawsuit, a motion to disqualify counsel, and the immunities under Section 10. And I would argue under the presentment requirement itself at issue in this case. So to the extent that Shapiro held that presentment...
Well, I suppose it doesn't come up. I mean, it's hard to see that it would come up because it's only coming up because somebody hasn't waived it. I mean,
That's correct. And in this case, it was the very first thing that was filed in the trial court.
But don't we have case law that says that, at least with respect to the question of immunity, if it's not raised in a motion to dismiss, then it gets kicked over, or it's relegated to the category of affirmative defenses at the trial on the merits. Isn't that the way it plays out if you don't raise it in time?
So the way in which presentment has played out is sort of unique as a condition precedent to filing a lawsuit is if the plaintiff has pled it in the complaint, then it's an issue that has to be raised immediately, either in the answer or in the motion to dismiss. If it's not pled in the complaint, then essentially it can be raised at any time. But what the courts have said when it comes to...
Was it subject matter jurisdiction? Is that why?
It is not jurisdictional. The courts have said it's not jurisdictional.
So how can it be raised at any time?
I think what the way the courts have put it is it's related to immunity, even if it's not immunity per se. And the reason I think you apply the present execution doctrine is because when you have issues that relate to immunity, the courts have emphasized there is an importance on addressing them early on in the case. And the city and any public employer is going to lose the right to avoid a vulnerability to a lawsuit that it otherwise wouldn't be subject to. This was the case not only in the Shapiro case, but also in the Daviega versus Boston Public Health Commission, where the public employer, the health commission in that case, filed a similar motion to dismiss to what the city of Somerville did here on the grounds of presentment, and the motion was denied at the trial court. And then the public employer sought interlocutory review, and a single justice denied that review on the basis that a motion to dismiss predicated on Chapter 258 is subject to the doctrine of present execution. And so that's how that appeal proceeded, and this court cited that exact progression when that case eventually worked its way up to the SJC.
Hey, can I ask you, in the Shapiro case, I think I know the author, in the Shapiro case, was it because of the particular nature of the issue here, and that is whether the presentment required retroactively, that really created this as an issue that had to be dealt with right away?
I think it's an interesting point. I think when you read the paragraph I quoted earlier, though, at bottom, it gets back to the presentment requirement overall. So in that case, the city of Worcester filed a motion to dismiss on the basis that they felt the presentment requirements weren't met. Whether or not that was because the presentment requirement, they thought that it was a nuisance claim that previously wasn't on their Tort Claims Act because of the Morrissey decision, I think the issue is essentially the same, and the analysis would apply the same when you apply that two-pronged test for present execution.
Now, let's assume that we do here, that we agree that you can appeal. Let's turn to the issue of whether the presentment was adequate here.
Sure.
It did give notice to the city of an injury to the child, and the judge below found that it wasn't perfect, but it was good enough.
Correct. So the test that the courts have set out for the content of the adequacy of a letter is it precise in identifying the legal basis of the claim, and is it not so obscure so as to mislead or baffle public officials on whether someone is presenting a claim before they file a lawsuit that is subject to Chapter 258. And the city's position is that the letter, the only letter that went to the city's chief executive officer before the lawsuit was filed, is a letter, an attorney representing a client asking for copies of records relating to a report.
Doesn't it describe the injury?
It doesn't describe the injuries in any level of detail. It does say...
But enough to just sort of make an ordinary person realize that this is not something that happens every day.
Well, I think that's...
And gives you enough of a clue as to the kind of, what happened, basically. I don't think you have to be a genius to figure it out.
I think the letter tells you that an incident took place and a person was injured. It doesn't go the step of saying, and we are making a claim against the city. It doesn't include the
Why
word...
do you think they're writing to the city?
I believe they were writing to the city to request copy of records and essentially information gathering to build potentially their case, whether it was going to be against the city or another party.
Against whom?
It could, well,
other than the city?
for example, at this point, the plaintiff has amended their complaint several times in the trial court. Now they've brought an action against, I believe, the general contractor that was involved in building the school, the door manufacturer, rather. So, just for practical purposes, public employers get these types of letters all the time in terms of folks seeking copies of records. And these are records that we maintain, and the records were produced in this case. And nothing further was heard from the plaintiff's counsel until the lawsuit was filed.
All right, thank you.
Thank you.
Good morning. My name is David Hassan. I represent Edgar Rodriguez. He's the father of Rodrigo Rodriguez, the 7-year-old child who was hit on the head as he was leaving school one day. And I want to direct the court's attention to the Court of Appeals decision. In that decision, the Court of Appeals gave the city some free legal advice. They said, your appeal is defective. You haven't complied with Rule 9C. You haven't denied the presentment allegation with specificity. We suggest you dismiss your appeal, amend your answer, and start over again. The city of Somerville ignored that request, and that's why we're here today. We claim that the city of Somerville's appeal is defective for that reason. And in addition, it's defective. Why are we talking about a letter on a motion to dismiss? As this court is well aware, under Rule 12b, a motion to dismiss is directed towards the pleadings. The pleadings in this case allege adequate prerequisites before the lawsuit was instituted. We shouldn't even be talking about the contents of a letter. That really should be a motion for summary judgment. And the reason it should be a motion for summary judgment is there are other factual defenses that the plaintiff could have raised if he had had the opportunity to conduct discovery. There's actual notice, for example, as an exception. Finally, another reason why this case is not properly before the court is Rule 15a. I'm not the first lawyer in the case. I'm not the one who sent the first letter. Hope you mentioned that in your opinion. But I do want to point out that since I became the lawyer, we have amended the complaint, and we've brought in new parties. We've had new allegations. If this court decides to accept this appeal, you're going to be inundated with work. You're going to be on first-name basis with the nighttime cleaning crew at the Supreme Judicial Court, because there are a lot of people out there who are unhappy with the court's rulings on motions to dismiss. And because the city of Somerville has misconstrued the applicable precedent, they haven't dealt with that. The applicable precedent is clear that the cases have to do with immunity. And there's a two-pronged test, as my brother has also told you. That two-pronged test has only been met so far in immunity cases. This is a simple case where the city is not happy with the trial court's decision, and they're appealing it. But there's no reason this court should be entertaining this appeal at the present time.
What about Shapiro?
Shapiro is an immunity case. And
Even though it discusses presentment?
excuse me?
Even though it discusses presentment?
Yes, because what we're talking about in an immunity case is that the person shouldn't undergo the lawsuit because they're immune from it. Look, nobody wants to be involved in a lawsuit, and somebody who doesn't want to be involved in a lawsuit could construe it as being harassing. But when you have specific immunity from lawsuit, that's a proper time for talking about a presentment issue at the very beginning.
If I could turn to Rule 15a. So is it your view that another attorney writes a letter which falls short of a presentment, files an action, new attorney comes in and says, oh dear, that's not a very good presentment letter. It would probably be dismissed if the issue were raised. I'm going to now present a new presentment letter and then amend the complaint and that's cured?
Well, that's exactly what I did. So the Court of Appeals suggested that the City of Somerville do that to amend their answer. And so if it's okay for them to use the magic of Rule 15a to retroactively amend your complaint, the plaintiff did what the Court of Appeals suggested.
And were you within the statute of limitations for the new amendment?
Well, we may see you in a couple years on that issue.
Because you're seeking to go back in time to the initial.
Right. We're trying to relate back to the initial
Relate back
filing.
to it?
Yes.
But your basic claim is that you can cure a failure of presentment.
Well, in the same way you can cure a waiver of the presentment defense, you can cure that. I would point out that at the time we did that, we had also added other defendants to the case. So that what we're talking about is a case that was alive, wasn't just resting upon a defective presentment. So I don't know if this court wants to get into the whole issue of what happened at the trial court level. It's not clear to me standing here whether that issue was before the court. However, I do want to address that briefly and to say this. This whole issue of notice to the city of Somerville under the facts of this case is an empty formalism. And what do I mean by that? This case happened at a Somerville school and it was witnessed by Somerville employees. Our client, the 7-year-old, is not a reliable source of information. And all we know about the case, all we know about how the facts that happen here come from the defendant. So the whole idea that the city of Somerville was baffled and the letter was obscure, they didn't know what was going on, that's not very credible. Here, the plaintiff was depending upon the defendant for information about what happened. And I think that influenced the trial judge, that under the facts of this case, the very notion of notice to the defendant was really not something that should be pushed too strongly. That letter could have been stronger. However, it did mention this metal bar falling on this little kid's head, and that's a res ipsa case. And the legal theory is not very obscure in that regard. Unlike earlier cases that had to do where the plaintiff's lawyer sent a series of letters about a motor vehicle accident. Obviously, a motor vehicle accident can occur without negligence. But here, where the plaintiff was totally innocent, just walking under a doorway, and this thing fell on his head, I don't think you need a lot of legal experts to identify what the legal theory would be. Further, the letter informed the city that this child had been injured. Now, what's happened here, really, on these presentment letters is that the city has tried to turn them into what might be called a trap for the unwary. But the trial judge correctly saw that the purpose of the statute had been fulfilled. We put the city on notice. This kid had been subject to a thing that fell on his head, a res ipsa case, that he had been injured. And I think that really at that point it was incumbent upon the city of Somerville to do something if they wanted more information. They could have easily contacted the plaintiff's lawyer. They could have engaged in settlement discussions. They already had enough information to address the physical question of the door.
How could they have begun negotiations towards settlement when all you asked for is a report of the incident?
Okay, let's talk about that because that's important. The statute does not require a plaintiff to make a demand. So a demand is when you take all the facts of the case, liability and damages, and reduce it to a number. That's not the statutory requirement. And the statutory requirement is just to tell the city about what happened and that you are making a claim on that behalf. And so the city had adequate information both to cure the physical problem about the door and secondly to investigate further. That's all the statute's trying to accomplish. It's not requiring the plaintiff to actually reduce the case to a number or engage in any kind of negotiations. So the other thing is that if this court rules on their motion, you'll be setting the rules of civil procedure back hundreds of years. And why do I say that? Because you'll be ruling upon the adequacy of a letter that was not included in the complaint. And therefore, there should be no reason why that letter should have even come up before any of the courts. Thank you.
Thank you, counsel.